Islam, 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 Islam. Back with another one. You thought I was going to bring another one. Let's talk about it. Let's talk about qualified immunity when the police pulling you over. All the police have immunity for violation of the Fourth Amendment. I'm here to tell you, no, they don't. Let's talk about it. Gaynor versus Rogers. This is a case where police thought they had qualified immunity and they didn't. We should be public now, hopefully. Let's talk about qualified immunity, Gaynor versus Rogers. You can look this up, Gaynor versus Rogers. If you know anything about Gaynor cases, Gaynor got a bunch of cases. Probably have to start your thing over.
That's it.
Oh. Gaynor had a lot of cases. Is well known for suing police. Look up the Gaynor cases. Gaynor versus Douglas. Gaynor versus Rogers. Gaynor had a few cases. All right, we're going to go through some case law. When you come to college.org, this type of studies you get, we go through case law. We got a free law library. I'm updating that every day, including case laws and PDFs and free ebooks. All right, so let's get into it. This Gaynor versus Rogers case. All right, let's talk about how these police violate the Fourth Amendment. And then when you come with your lawsuit under Title 42 USC 1983, the first thing they try to do is file for qualified immunity. But the Constitution doesn't give them qualified immunity when they violate the Constitution. Once they violate the Constitution, they violate their oath of office and they step out of their protection as an officer. So we talked about this yesterday. So let's go further in with this one, with this Gaynor versus Rogers case. All right, this is an appeal from the district court's denial of a motion for summary judgment for claims brought against the defendant, police officer Scott Rogers, under 42 USC 1983. This is 1988. For false arrest, use of excessive force, and violation of his First Amendment rights. Rogers sought summary judgment on the ground of qualified immunity. The district court determined that genuine issues of material fact existed and denied the motion. We affirmed the judgment of the district court. Period. So, like I say, Title 42 was brought in the district court against the police officer named Scott Rogers. Scott Rogers tried to file an appeal to the appellate court. And when he tried to file an appeal, he tried to allege that he had qualified immunity. He put in a motion for a summary judgment. His motion was denied on the grounds that he was not protected by qualified immunity. Now let's break this down. Why this brother was not, he didn't qualify for immunity. All right, let's look at the background of the case. Okay, it says on the afternoon, March 24th, 1989, John Michael Gaynor was observed by Officer Rogers carrying a 12-foot by 6-foot wooden cross through downtown Moorhead, Minnesota, and distributing leaflets. Gaynor was walking with a companion, Todd Dittmer. Rogers claims to have approached the two men because he suspected Gaynor might be intoxicated, soliciting, begging, obstructing traffic, or or otherwise creating a public nuisance. When questioned, Gaynor informed Rogers of his walk-in ministry and his personal quest to carry the cross along the border of the United States to spread his religious message. After obtaining one of Gaynor's leaflets, Rogers asked if Gaynor was an ordained minister. Gaynor responded affirmatively, and Rogers then asked for identification. Gaynor pulled out a copy of the United States Constitution and informed Rogers that he had the constitutional right not to produce identification. Let's talk about it. All right, some of y'all be scared to enforce y'all rights, and here go Gaynor. 1989 was doing this. Come on now. He was already telling the police he don't have to produce no identification because his constitutional rights. What I tell y'all, y'all better start walking around with that constitution in your back pocket. You don't need no ID. Noble Drew Ali said the nationality card is not needed. Why did Noble Drew Ali say that? Because you don't supposed to be identifying yourself if there's no crime committed. If there's no crime committed, why would I be identifying myself? Why would I pull out an ID if I didn't commit a crime? All right, Gaynor versus Rogers, he won this case. All right, only person have to identify themselves is somebody who's in the middle of a crime. So if the police walk up and he see me smacking the shit out of a bitch or smacking the shit out of somebody, you feel me? Then of course I would not have the freedom to walk away from that situation. You see what I'm saying? So if you putting your hands on somebody, you harming somebody, the police see a burning house, then yeah, they have the right to step in and intervene with those type of situations. Any human being does. But what happens when the police just suspect you of wrongdoing? What's the suspicion versus actually witnessing the crime? That's a big difference. All right, let's talk about it. Let's talk about it. Okay, let's talk about qualified immunity. What is it? Qualified immunity is a type of legal immunity that protects a government official from lawsuits alleging that the official violated a plaintiff's rights, only allowing suits where officials violated a clearly established statutory or constitutional right. Qualified immunity balances two important interests: the need to hold public officials accountable when they exercise power irresponsibly, and the need to shield officials from harassment, distraction, and liability when they perform their duties reasonably. And that's followed by case law, Pearson versus Callahan. All right. So we know what qualified immunity is. It's just like your immune system or any type of immunity. All right. To be immune from something means that you protected from it. Okay. So the police have a thing called qualified immunity, meaning that they can be protected from the acts they perform while they're in uniform or on duty. But they have to qualify for that. Now, how do you qualify for that? First of all, only way you can qualify for that is that they didn't violate a clearly established statutory or constitutional right. If they violated a statutory or constitutional right, the police do not qualify for immunity. All right, so they can't use that as a defense once they violate the constitutional right of the Fourth Amendment. So say if they pull you over, all right, they pull you over and without a warrant, okay, they don't qualify for qualified immunity, okay? All right, let's take some questions. I see a couple questions on my TikTok. I see some on Facebook. Okay, Kimberly Marie say, where do I go online to print out the amendments, etc.? I don't know about all of them, but I want to learn. Okay, Kimberly, the best place I go is Cornell Law School. Cornell Law School, you can come on here or you can go on Justia. It's the best two resources I use. Cornell Law School is an actual online law school provided by the government, United States government. Okay, so You can go to Cornell Law School, type in the amendments. It'll bring up the whole Constitution. Put in U.S. Constitution. It'll break down the whole Constitution for you, and it also have notes for you. You can also click on these tabs if you don't understand these words. Uh, Simply by clicking on it, like legal immunity, you can click on that. It brings you to another page which explains what immunity is. Okay. Also, another group, a good resource I use is called Hillsdale College. Hillsdale College. Shout out to Hillsdale College. It's an online college, and it's free constitutional courses from a college professional. So you want to go to Hillsdale College. Also, you can plug into the consciouscollege.org, and we give away uh, constitutional classes every Sunday. Enroll in the consciouscollege.org. And if you stick around to the end of this video, I'm giving out the password for the free 2-week trial. All right. Okay, let's take some more questions. Hope I answered that question. Let's take some more questions. There we go. All right, 1 second. I'm trying to navigate through these questions. I'm a little new to this. Okay. BC Scanner said, never talk to the police. That's correct. Never volunteer information, because anything you say can't be held against you. Jurisdiction means, diction is short for dictionary. Jurisdiction means everything you say out your mouth. Diction is short for dictionary. So jurisdiction is the legal words you use. You consent to things. Like if they ask you, hey, can I search the car? You got the right to say no. You actually got the right to say no. You can't search my car. All right. And what they gonna do? They have to bring out some dogs or do something else. But at the end of the day, they're supposed to have a search warrant. So if they bring out anything, if they don't got the search warrant, then you got them. BC Scanner say FTP, film the police. There you go. We're gonna talk about that in Conscious College. What's the first thing you supposed to do when you pulled over? Let's talk about that. This brother, in this case, Gainer versus Rogers, he had his Constitution in the back pocket. Let's talk about it. All right. BC Scanner said they use it for everything. Did we just become friends, best friends? I don't know, BC Scanner, but this is what we do every day. This is my life right here, brother. Sister, whatever you may be, but yeah, you want to be best friends with me, because I'm a next friend. I'm not only a best friend, I can be your next friend. And your next friend in court is somebody who can help you and assist you in court, isn't it? Gifted Mac says, here in NYC, there's an I-card issue for me. They are operating under color of law and depriving me of my rights. Will my letters be to Attorney General of the state? No. Gifted me. Your letters, first of all, you shouldn't be sending no letters. You shouldn't be filing a civic action, a civil action under Title 42 USC 1983. All right. Deprivation of rights under color of law. Go watch my live video yesterday. We talked about that. All right. When you join the Conscious College, that's what we're going to deal with. Title 42 USC 1983, Civil Action for Deprivation of Rights. All right. This is what everybody needs to be filing in your federal district court. This don't go to the state court. This is a federal claim. So this goes for every state. All right. It says every person who under color of any statute, ordinance, regulation, custom, or usage of any state or territory or the District of Columbia subjects causes to be subject any citizen of the United States or other person within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws shall be liable to the party injured in an action at law, suit in equity, or other proper proceeding for redress. All right, so this is your action. This is your civil action anytime somebody deprive you of your rights. Okay. Kimberly Marie said, thank you with gratitude. You're most welcome. I see you tap in every day, Kimberly, for sure. Hope you get something out of this. All right, let's go look at my Facebook. All right, let's look at Facebook questions. We got Facebook users say I'm here. Okay, somebody said Grand Rising, Grand Rich Risings. Wizard Kelly said, get him, sheep. You already know I'm on my glow. That year glow. I got that year glow attitude going on. You feel me? Wizard Kelly say, don't go live this morning no more. You sound asleep just like the people sleeping on their rights. Now I'm finna wake them up today. Islam, it's time for the great wake up. It says, okay, sheep, wake up. It says accountability. All right, you're right. You know what I'm saying? I've come a little mild this morning, but don't get it twisted. I'm still dropping hot facts. I'm just trying to stay calm, cool, and collect. You feel me? Accountability. Yes, police have to take accountability. You know what I'm saying? They can't just be out here violating the law and not be held accountable like they're immune to the law. Because for one, everybody is equal under the law. Nobody is above the law. Everybody can be brought for a civil action, says every person who under color of any statute. So it don't matter if they come artificial law or not, everybody can be brought to justice. All right? Everybody can be brought to justice. All right? Gift the Meek said, I can't even go outside. There's no warrant. But that's enough. That's not enough people enforcing their rights. If we collectively come together, start class action lawsuits, this is the point of nation and nation building. ConsciousCollege.org, this is what we doing. We nation building so we can come at these culprits. See what I'm saying? Wizard Kelly, let's go back to my Facebook. Said Wizard Kelly says, now I seek the best friend spot taken by Bree. Tell them don't take it too far now. Now you heard her. You heard it, man. If somebody else got the best friend spot, man, I can be your next friend, but you know what I'm saying? The best friend spot I already taken. I'm already spoken for. Islam. Jason Watson, brother Jason Watson said, damn it, Curbs. What's up, my boy J-Dub? J-Dub, what's up, brother? Let's see what else we got. You can show the on the screen. You can show the okay. Okay, see that? Okay. Wizard Kelly said spoken for. I can show whichever one I want to show. Type. I'm just gonna click on. Okay. All right, that's cool. I'm just going through through the comments. You know what I'm saying? Let's talk about something else dealing with the deprivation of your rights. Okay, I'm bringing y'all 2 case laws today. 2 case laws. Yeah, she bringing 2 case laws today. You feel me? I might have to double up. I got too many. I'm learning more as I go, and I got 1,200 coming in my new book, Our Self Law, coming real soon. You know what I'm saying? So we got 2 case laws to talk about today. We're going to talk about fruit from the poisonous tree. Yeah. Gift the Meek say, not Kimberly Marie say, I'm typing it every day because I want to learn everything the right way. That's right. We got to unlearn, relearn. That's why I'm speaking up, because I'm done being humble, because there's too many people online creating false narratives. They telling people you can do this, do that. You can't do this, do that. The whole time, they ain't got nothing they standing on. Where they getting this from? You know what I'm saying? That's what I'll be wondering. Where is you getting this from? You understand? Because you know what I'm saying? Because everything I say, you can go back and verify. That's the thing about me, is that I'm giving you something you can actually go stand on, you can use, you can print this out. You see what I'm saying? These are real citations. And not only that, can't no judge override these citations. So it ain't what I'm saying. It's with these citations saying, I'm gonna break it down. You feel me? We're gonna break this down. We're not gonna leave a person confused. It's too much confusion. You understand me? Uh, Kimberly Marie say, how often is classes throughout the week? Just trying to stay on track so I won't miss everything. I'm coming live every day. Conscious College every Sunday. But we're gonna be coming with additional classes. It's gonna be announced. You should be receiving inboxes for it in the Conscious College. Sent out the message to everybody this morning. Let them know. Everybody that comes to Sunday school this Sunday, you're getting a free 15-minute consultation from me, Grand Sheik, personally. We're gonna schedule them, get my Calendly app together, and I'm gonna schedule these consultations. All right. So free. I don't care what you want to talk about. You want to talk about credit. You want to talk about bill discharging. You want to talk about your case. You want to talk about some relationship advice. You want to talk about Quran. I don't care. You get free 15 minutes when you sign in to the Conscious College Sunday School. All right. All right. We're gonna schedule it this Sunday. Okay. Gifted Me said, how do I go to court and file a civil action when I can't go outside? You can do it by mail, brother. Court is through the mail. All right. Don't be falling victim to these people harassment. You understand me? You can file by mail in the state's courts. You can e-file in federal court. You can't e-file, but you can file by mail. You understand? You can file by mail, man. Certified mail. They got sites that mail stuff for you. You know what I'm saying? Can someone go for me, man? You gotta learn how to do this for yourself, man. You can't look for no savior, man. What happened if you ain't got nobody to go with you, man? I'm gonna tell you what to do. Go on certifiedmail.com, man. You can send certified mail for a few dollars straight from the house. You see what I'm saying? All you gotta do is have a computer. All you gotta do is have a computer. I promise you. I don't go out to the post office for everything. Some stuff I send through the computer. But if not, you know what I'm saying? If you can't go to the post office, definitely go through the computer. All right. You know what I'm saying? So yeah, free 15-minute consultation, man. Sign up for the Conscious College. Before I go into this next case, I'm gonna give y'all the free password. The password for the Conscious College free 2-week trial is here. It's your email. If you send me your email, you get 2 weeks free Conscious College. If you come to Sunday school and 2 weeks free, you get a free 15-month consultation. Come on, man. How can you beat that? And then after that 2 weeks, it's only $50 a month. You getting 4 Sunday schools, 2 hours. I'm going through this. You can inbox me your questions. Then I'm putting more classes. Like we're gonna have a class for Friday for people who joined the estate plan. When you get the estate plan course, I'm putting a free class once a month for that. All right, so I'm doing additional things. Grand Sheik out here working. Uh, Gifted Me said, where do we send our email? Send an email to my DM. DM me your email or inbox me your email. Or you can even comment on the post your email. You know what I'm saying? And I'm gonna send you the link to the Conscious College. It's gonna ask you for your payment information, but it's not gonna charge your card. All right, let's put that out there. Because after the 2 weeks free trial, it's gonna charge your card. It's only $50 a month though. But you're gonna get way more than $50 worth of stuff. Like I say, I'm giving y'all free law library. I'm giving y'all meetings every week. I'm giving y'all consultations. You know what I'm saying? It's gonna lead to remedy and receipts. I guarantee. All right. All right. So tap in with Grand Sheik for sure. All right. Let's talk about it. Okay. Silverthorne Lumber Incorporated versus United States. What happened here? Okay, let's talk about this case. Okay, now this is a case about the Fourth Amendment. Let's talk about it. Okay. The syllabus of this case says the Fourth Amendment protects a corporation and its officers from compulsory production of the corporate books and papers for use in a criminal proceeding against them when the information upon which the subpoenas were framed was derived by the government through a previous unconstitutional search and seizure. All right, planned and executed by its officials under color of a void writ, provided the defense of the amendment be seasonably interposed and not first raised as a collateral issue at the trial of the indictment. All right, the rights of a corporation against unlawful search and seizure are to be protected, even if it be not protected by the Fifth Amendment from compulsory production of incriminating documents. Now this was reversed. All right. They had to reverse the decision against you know what I'm saying, the United States. Why? Because the Fourth Amendment protected this person. They tried to say that they can search this person without a search warrant. They can search your corporation. You know what I'm saying? So it don't matter if you come in your straw man or not. The Fourth Amendment still protects you. This says the Fourth Amendment protects a corporation. All right? So you have protection under the corporation as well as protection under your natural person. Okay? This case right here in 1920 gave rise to the fruit from the poisonous tree doctrine. A lot of y'all don't understand that. So what it's saying is, once it's an unconstitutional search and seizure, don't matter what you find. It's immunity in that. It's protection from the Fourth Amendment. All right? I'm giving y'all the sauce. All right? This is where the Fourth Amendment comes from. I mean, not the Fourth Amendment, but the fruit from the poisonous tree doctrine come from. All right? Let's read what the fruit from the poisonous tree doctrine is. Thought I had it pulled up. Let me see, pull it back up. All right, and this is all on Cornell Law School. All right, let's talk about the fruit from the poisonous tree, because I love fruit, but you can't eat fruit from a poisonous tree because that means the fruit is poison. All right, so let's talk about that. Fruit of the poisonous tree is a doctrine that extends the exclusionary rule. It extends the exclusionary rule to make evidence inadmissible in court if it is derived from evidence that was illegally obtained. All right? As the metaphor suggests, if the evidential tree is tainted, so is it fruit. Period. The doctrine was established in 1920 by the decision of Silverhorn Lumber Company versus United States. And the phrase "fruit of the poisonous tree" was coined by Justice Frankfurter in his 1939 opinion in Nordon versus United States. The rule typically bars even testimonial evidence resulting from excludable evidence such as confession. Wait, so that don't mean even if you confess on yourself, you can snitch on yourself, and that can be excluded. The exclusionary rule deals with the fruit of the poisonous tree. So when the police pull you over under Gainer versus Rogers, they say, look, can I search you? You ain't got no search warrant. Say I pull out my Constitution and say, do you know the Fourth Amendment? He still violate the Fourth Amendment. He go in my pocket. Say he find a gun. Say he find an arm. We ain't gonna call no gun. We're gonna use correct terminology. Say he find an arm, which you call a firearm or a gun. Say he find a pistol in my pocket, but he didn't have a search warrant. And then say if I get an interrogation room, I tell on myself. I say, man, yeah, that was my gun. I say, yeah, that was my gun. Not knowing it's called an arm. Say I incriminate myself on the Fifth Amendment, where the fruit from the Poisonous Tree Act protects you from all your errors. Because It don't matter what you did. It's a matter what they do. Now, if you consent, that's different. If you consent to the search, that's different. But if you don't consent, the fruit of the poisonous tree protects you. It says any evidence that the police gain on you, if the evidence is not gained by a search warrant, the fruit of the poisonous tree doctrine, which is case law, protects you. Okay? It says the evidence is inadmissible. Do you know what that means? Let's look at what evidence inadmissible means. I got two words combination. Admissible evidence. Admissible evidence is evidence that may be presented by the trier of fact, i.e., the judge or jury, for them to consider in deciding the case. Compare inadmissible evidence. That's what I was trying to compare, but it went to something else. Okay, let's go. Inadmissible evidence. Here we go. In contrast to admissible evidence, inadmissible evidence is evidence that may not be introduced by a fact finder, usually the judge or jury, to prove the party's claim. The federal rules of evidence, which apply to all civil and criminal federal court proceedings, govern whether evidence is inadmissible. And that's Federal Rule of Evidence 1101B. All right, that's Federal Rule of Evidence 1101B. If the evidence does not meet standards of relevance, the privilege or public policy exists. The qualification of witnesses or the identification of evidence is at issue, or the evidence is unlawfully gathered, then it is inadmissible. Federal Rule of Evidence 104A. That's Federal Rule of Evidence 104A. But these rules, except for those on privilege, does not apply to the trial judge's determination on a preliminary question of fact governing admissibility. All right, what is that saying, Grand Sheik? That's saying that if a witness or some type of evidence or some type of confession, anything that is questionable, that said it was gained unlawfully gathered, meaning if they got this in violation of the Constitution, if they broke the law to try to catch you breaking the law, what does that mean? That means that it's not able to be used to determine the outcome of the case. That's what it means. They cannot use this to determine the outcome of the case. It cannot be based on the evidence, and it has to be stricken from the record. All right? Let's talk about what you're supposed to do then. You're supposed to file a motion to suppress evidence. Okay? File a motion to suppress evidence. That's supposed to be your first motion to dismiss and suppress evidence for violation of the Fourth Amendment. Okay? Because all this evidence is supposed to be inadmissible. So that means if I was pulled over, and I had a gun in the car, and the police ain't have a search warrant, but they found something by illegally searching the car, I didn't give consent. It's inadmissible evidence. It can be beat by a motion to dismiss. If they deny your motion to dismiss, you can appeal that motion. Come to theconsciouscollege.org, and we're going to get you right. Peace and love, Morris. I'm out of here.